Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President of Legal Studies here at the Foundation. For those of you not familiar with the Foundation, we're in our 47th year of free enterprise advocacy and education. If you want to know more about the work that we do on a pretty wide range of issues that affect the free enterprise system and individual and economic liberties, please check out our website at wlf.org. We're pleased that you've chosen to spend your next hour with of your busy day with us. As you may know, WLF is one of the more active amicus filers in the Supreme Court among public interest legal groups. Our record on the merits was mixed this term, with 5 positive outcomes and 5 that were not positive outcomes. We fared better, relatively speaking, in supporting certiorari petitions, which is something we do frequently as well. Of the 13 cert stage briefs we filed this term, 4 were granted in cases pending for the next term, 5 were denied, and 4 are still pending. So keep an eye on those for sure. And as we have done for the last 36 years, we've assembled a panel of appellate experts and SCOTUS big thinkers to discuss term 2023. I'll introduce the speakers very briefly. Michael Kimberly is co-chair of McDermott, Will, and Emery's Supreme Court and Appellate Practice and Government and Regulatory Litigation Group. He has given more than 30 appellate arguments, including 8 for the U.S. Supreme Court. He is a visiting lecturer in law at Yale Law School, where he co-directs the Yale Law School Supreme Court Clinic. Michael served as a clerk to the U.S. Court of Appeals for the Ninth Circuit Judge Michael Hawkins. Joining us also is Elizabeth Slattery, who is Director of Constitutional Scholarship at Pacific Legal Foundation. She leads a team that incubates and promotes legal theories among elite legal audiences to prepare the ground for courts and policymakers to uphold the rule of law consistent with PLF's vision of the Constitution. She has testified before Congress and is a frequent legal commentator in print, radio, and television. She has produced 2 podcasts on the U.S. Supreme Court and chronicles Supreme Court happenings at SCOTUS Ladens. Finally, Daniel Rubens is a partner in the New York office of Orrick, Herrington, and Sutcliffe. He served as a law clerk to U.S. Supreme Court Justice Ruth Bader Ginsburg, Judge Robert Katzmann of the U.S. Court of Appeals for the Second Circuit, and Judge Jed Rakoff of the U.S. District Court for the Southern District of New York, one of those rare trifectas of clerking, which must bring extremely a valuable experience. Along with several of his colleagues at Orrick, Danny drafted an amicus brief for WLF supporting certiorari for a securities fraud class action case out of the Ninth Circuit. The court granted certiorari in that case, and they will hear arguments in that case during its October term till 2024. I want to note to our viewers that the program is being recorded and questions can be asked by using the Q&A function on the Zoom webinar toolbar. We're going to have our panelists each issue an opening statement, and then we will proceed with sort of a Q&A approach. Michael, if you could get us started.
Great. Thanks, Glenn. I appreciate it, and I'm glad to be here. We've been asked to share sort of our initial impressions and thoughts of the past term, and I thought what I would do is share initially some thoughts, particularly with respect to the area where I practice, which is in both generally the Supreme Court and appellate area, but more specifically the APA space and administrative law. And I think it would be awfully hard to miss one of the unifying themes across many of the court's significant cases this term, I think is a reflection of the court's distrust of the administrative state and its interest in cutting back on the administrative state's power. And I think you see that in a number of cases. Obviously, everyone's been hearing a lot about Loper Bright and Relentless and the overturning of Chevron deference. That is a significant move that has pulled authority back from administrative agencies and returned it to the courts to interpret statutes. And it'll be interesting to see if it extends also to a different approach under Kaiser and their interpretation of regulations. We saw it also in a case called Jarkissi concerning the Seventh Amendment right to trial by jury. This, I think, is probably as consequential, maybe even more consequential than Loper Bright and the overturning of Chevron deference. As a practical matter, it's going to make it nearly impossible for agencies to assess penalties and fines for enforcement of regulatory schemes against private entities. You see it also in less well-covered cases like Corner Post, which has extended the circumstances under which private parties can bring suits against agencies to press some of the issues now that are made easier to litigate with Chevron out the window. And you see it even in cases like Ohio against EPA, which is a environmental protection issue concerning the Clean Air Act. And although it's a technical case about stays and the spreading of air pollutants from state to state, it is ultimately also about the standards that apply in APA cases and the extent to which this court, the Supreme Court in particular, but I think other courts taking its direction, are likely to push the arbitrary and capricious standard of review. So I think, taking all those cases together and others reflect generally a diminishment of the relative power of agencies vis-a-vis courts. I'd add just a couple of other thoughts. The first is I think this term has also shown that this really is the Roberts and Kavanaugh court. Chief Justice Roberts was in the majority almost 97% of the time this term, and Justice Kavanaugh was very close behind him at 95%. No other justice came close to that. You saw Justice Barrett just about at 90%, but then everybody else falling back into the 80s and 70s. In the frequency with which they were in the majorities. It's clear that the liberals are very much not in control, and that's reflected too in the very high number of dissents and concurring opinions that you've seen, many by the more liberal justices on the court. The second observation I'd make is I've been interested to watch Justice Kennedy's approach to the developments that we've seen in the court lately. She's been a strong defender, I think, prophylactically, albeit ineffectively, of stare decisis, and has worked hard to characterize the more conservative side of the court as an activist court. It's interesting to see how those arguments are landing, which is to say, not especially effectively. And I'm also not sure it's entirely, on the one hand, I think it's easy to understand why, from the perspective of the more liberal justices on the court, this feels like activism. At the same time, I think when you look at cases like Loper Bright, it's hard to understand it as activism as much as it is just determining who's going to decide. Activism ultimately is about judges engaging in policymaking. And I don't take any of these cases really to be policymaking cases. They're really cases about allocating authority among the branches of government. How that authority is exercised may end up implicating that concern, but that's something we'll have to see in the application.
Thank you, Michael. Elizabeth?
Thank you, Glenn. It's a pleasure to be here today with you. So thank you for inviting me. So I think it's a cliche to say that this was a blockbuster term. It seems like just about every term in recent years has been a blockbuster one. And two cases involving former President Trump loomed large over much of this term. But there were a number of important cases across other areas. So I'd like to start off with just a few observations about the state of property rights and then also separation of powers. I think it certainly helps from my perspective. It helps that these happen to be areas the Chief Justice seems to care about himself. And oftentimes in cases involving property, he's writing a majority opinion or, there have been some rare Chief Justice Roberts lone dissents in property cases. So I think it's an area that he cares about, and it shows. So the Roberts Court has been, I would say, increasingly protective of private property. At Pacific Legal Foundation, we've been working for the last 50 years to level it up to the same constitutional protection that some other, you might say, more celebrated individual liberties enjoy. So I want to mention two property cases from this term, one of which, Sheets versus County of El Dorado, was a Pacific Legal Foundation case, and then De Villiers versus Texas, which was litigated by our friends at the Institute for Justice. So both ended up being narrow, unanimous decisions, leaving bigger issues for another day. So Sheets was brought by our client, George Sheets. He wanted to build a small prefab home on a residential lot. And in order to get the necessary permit, the county was going to require him to pay more than $23,000 in a fee to mitigate local traffic congestion. And the fee was calculated using a rate schedule that was based on the type of development and its location, not the actual cost that could be attributed to the project itself. So he challenged this in state court, arguing that this is what's known as an unlawful exaction. And there's a line of cases going back to the 1980s, Nolan, Dolan, and Kuntz. Two of those are PLF cases, I would note. And these cases together stand for the proposition that the government can't use its power over land use permitting to extract for free what the takings clause would otherwise require them to pay for. So under these precedents, the government has to establish an essential nexus and a rough proportionality between a permit condition and the adverse public impacts the proposed development would cause. This applies to money. It applies to property. For example, in the Kuntz case, which was I think about 7 or 8 years ago now, a local government sought an easement on a developer's property. So we're not just talking about paying fees. So in Sheets, the California courts said that this traffic impact fee was not an unlawful exaction because it was imposed by legislation rather than ad hoc and by an administrative body. And this is an issue that has divided state and lower federal courts for a number of years. So we were pleased to see the court take up the issue, and thankfully the Supreme Court unanimously rejected the lower court's view in an opinion, a very brief opinion by Justice Barrett. So she explained in short that legislative exactions aren't categorically immune from this nexus and proportionality analysis. But the opinion did not address whether the particular fee satisfies those requirements. So George Sheets has to go back to the California courts. But Justice Barrett did note that giving special deference to legislative takings would make little sense. So categorically exempting them would make little sense historically because legislation is the conventional way that governments exercise their eminent domain power. So then turning to de Villiers versus Texas. So the overarching question was whether the Fifth Amendment's takings clause provides a judicially enforceable right to just compensation in the absence of a statute creating a cause of action. So just quick background, Texas built a barrier along a highway outside of Houston that was intended to prevent stormwater from flooding the highway. So that's good. But the bad news was it turned the surrounding private farmland into basically a lake for days at a time. So several property owners brought an inverse condemnation action in state court. So this is basically a cause of action to recover the value of property that's been taken without a formal condemnation proceeding. There were claims under both state and the state and federal constitutions. So then Texas removed the case to federal court, where it promptly sought to dismiss the case. Texas argued that the federal takings clause is not self-executing, so that means Congress needs to pass a law creating a cause of action to bring a suit, and Congress had not done so in this instance. Texas also argued that Section 1983, which allows suits against state officials for constitutional violations, would not authorize the claims here because they were directly against the state. The district court sided with the challengers, but in a brief, I think it was maybe a paragraph decision, the Fifth Circuit reversed, saying that the takings clause is not self-executing. So it comes to the Supreme Court, again, another unanimous decision. I think this one was maybe 6 pages, so very short, by Justice Thomas. They send the case back to the lower courts, noting that since there is an available Texas law that provides a cause of action, the court didn't need to decide this bigger question of whether the takings clause itself authorizes suits for just compensation when there's no applicable state law. So, De Villiers and the other property owners, their reward here is that they get to start all over. I suppose it's better than a loss, but it's not exactly the happiest ending. So, part of me wonders if the court didn't take on bigger issues in these cases because there were so many other issues in other areas, such as administrative law, the Trump cases, the social media cases, and others. And so they were trying to maybe deflect some of the heat with this area that gets a little bit less attention. So just to wrap up, I briefly want to say on the separation of powers front, obviously it was a big term, most notably with Chevron deference, finally getting the tombstone no one will miss, to quote Justice Gorsuch. I love that line. He's used it in a couple of writings now, and I'm glad it made it into a concurrence in Turing, Chevron deference. So the takeaway, I'm hopeful that without deference, agency regulators will think twice before they press interpretations of their enabling statutes that would expand their power. And maybe, just maybe, Congress will work a little bit harder on the front end to try to eliminate ambiguities in statutes. But the bottom line is that the Supreme Court had backed away from Chevron years ago. Unfortunately, it was still alive and well in the lower courts in many of the circuits. So making it clear that Chevron is no longer good law will hopefully mean that lower court judges will have to engage with statutory text more. That doesn't always mean agencies lose, although, of course, I hope they will more often than not.
Thanks, Elizabeth. Danny, if you could finish up the introductory comments.
Sure thing. Thanks, and glad to be here. So I guess going third, I'll do a little cleanup and talk about some of the other statutory decisions from the term and the kind of miscellaneous areas of law like bankruptcy, securities, preemption, arbitration. These are, among the less politically charged and headline-grabbing cases compared to what's been discussed, but these are still very important to those areas of law and to the broader economy. And I think they're also illuminating of where the court is. With a few exceptions, and this sort of picks up on what Elizabeth was saying, these decisions allowed the court to sort of come together in a term that was otherwise very momentous and often contentious and divisive. I do think it helps in understanding and assessing this to understand, there's a constraint on the court's own resources. And I think that a lot of those resources were consumed by the hot button cases, as you can see from the number of separate writings, which are often setting forth different methodological views kind of within the same ideological wing of the court. And I think some cases maybe took a disproportionate amount of attention, and then the court kind of had a little hydraulic pressure to find consensus among the remaining docket. I think there are kind of some limits to how much you can draw general conclusions and themes about these statutory cases, given the number of areas of law involved, each of which has its own quirks. But I just wanted to offer a few thoughts on maybe techniques or observations about how the court was able to largely come together in these. I think the first thing is that the questions that the court takes up were often fairly narrow. These are sometimes areas of law that the court will only take maybe a case or two a term. And because of the way the court fills its docket, which is really looking at circuit splits as the primary indicator of when it should take up a case, that doesn't always correspond to sort of the importance or consequence of an issue. So I think you can see this in some of the bankruptcy or arbitration cases. There's a bankruptcy case about party and interest standing for insurers. There is an arbitration case about whether you stay or dismiss district court litigation when arbitration is pending. And those issues are important to the parties and maybe to the bar, but probably not the top 10 list necessarily, even of what the bar really wants the court to resolve. So I think that just makes it kind of a little easier for the court to come to common ground. Another dynamic, a second dynamic, is that there is sometimes a convergence of positions among the parties on the other side of the V by the time the merits briefing was completed. This sort of has been happening, I think, maybe a little more frequently at the court, where there's a little shift in the framing of the cert stage to the merit stage. One example of this is in the Macquarie securities case, which I hope to talk about a little more later. And another example is the Starbucks versus McKinney case, which is on the standard for the National Labor Relations Board to get a preliminary injunction under the NLRA. I don't want to dwell on it, but basically the question presented was whether the traditional four-factor preliminary injunction test should govern, because some circuits were applying a more relaxed two-prong test. And by the time the case got up and the government filed its brief, they basically said, yeah, you probably should, you can do this under the four-prong test, that's fine. And that was kind of, in some ways, the issue the court was going to decide. So that makes it a little easier then for the court to kind of resolve it in a consensus way when there's just very little difference between what the parties are doing. And you can speculate why this might happen. I mean, I think one thing is that it's just a little more clear where the court is going to ultimately come out on some of these issues, given its current breakdown. So I think there is a tendency maybe for respondents in particular to kind of see the writing on the wall and then maybe shift to some fallback and trying to do damage control rather than kind of swinging for the fences. The last kind of dynamic I would note in these cases is the courts, and this happens, I think, every term, but the court's holdings were sometimes narrow to the point of being minimalist or even less than minimalist. And I'll talk about this a little more, I think, if we can get to it in the Quintero case about preemption. But there's some instances, where the court answered on a question that's pretty important, and then the decision and the content of the decision is basically, you got it wrong, kind of do it over, but I'm not going to really give you a whole lot more than that. And again, that I think that's a nice way to kind of have a unanimous court, but then sometimes I think you come away not having as much guidance to the bar or leaving a lot of open questions. So I think we'll get into more of that as we get into the specific cases. But I think it's always interesting to look at these cases in a term where there's a lot of hot button ideological stuff, because you do see the court working together and some interesting lineups and more on the kind of craft and superintendence of the legal system as opposed to with all the political overlays. So I do think it is illuminating to look at these cases and understanding where the court is more broadly.
Thank you, Danny. To start off our questions, I should ask, Michael, you were talking quite a bit about the relentless slope of right Ohio versus EPA type cases. And when you look at those, it makes you think about whether the judicial branch had a better term than the executive branch did. Everybody's been talking about what a great term the executive branch had, and we've aggregated a lot of authority in the hands of the executive, but judges seem to have come away from this with a lot more work to do.
A lot more work to do and a lot more power to exercise. I think it's right. I can't see a case for any branch doing better this term than the judicial branch. And in fact, in a way, there's two ways to think about the executive branch. You can think about the executive branch as the president. And from that perspective, the executive branch did pretty well. I think when you think about the executive branch more broadly and, pull in the I think by now it's close to 40 rulemaking administrative agencies that fall under it. It didn't have such a great term. It lost a fair amount of authority, both to make law and to enforce it. And, on the whole, I take this as part of the justice's project, as I suggested in my opening remarks, to begin reallocating authority among the branches. I think, when I was recently handling a case in the DC circuit that concerned in particular the APA and its background enactment. And when it was enacted in 1948, there were, I'd written it down, there were 13 volumes in the Code of Federal Regulations, and there were 20 agencies that engaged in rulemakings. And today there are 36, and there are 235 volumes of the Code of Federal Regulations. It's more than 18 times larger. The role that the administrative state plays today, when you compare it to when the APA was enacted in 1948, and even when you compare it to around when Chevron deference was decided, the Chevron case was decided in 1984, the administrative state is 50% larger than it was even then. And I think there's been building pressure against that sort of unchecked growth and the really at times intrusive authority that agencies have in certainly American legal life, but even day-to-day life. And so it's been interesting to see the judiciary re-exerting itself this term.
Elizabeth, does that give you any pause as an employee and believer of PLF and a believer in limited authority for the judiciary? Is there a concern that some might interpret that as judicial activism sort of rising, especially with so many of your and my ideological opponents out there painting the court as political and not guided by law?
Yeah, so Michael mentioned in his opening remarks that this really isn't about policy making, it's about interpreting the law. And so when I think about Loper Bright and some of the other cases, it really seems like they are restoring the balance that should be there between how the branches of government operate and requiring judges to judge. One thing I would note that I found maybe a little disheartening about the Loper Bright decision was that it's grounded in statutory grounds. It focused on the fact that Chevron could not be squared with Section 706 of the APA, which says that courts shall decide all relevant questions of law arising out of, reviewing an agency action. And there were a lot of platitudes about the separation of powers. But I think both Justice Thomas and Justice Gorsuch in their concurrences pointed out we shouldn't ignore the underlying separation of powers constitutional problems with giving so much power to agencies and judges abdicating their role in the system of actually saying what the law means. And so, I was a little disappointed that the case fell on APA grounds. And so, perhaps the future Congress will change the APA, and then we'll be back with a case like this in the future on constitutional grounds.
So, Michael, in terms of the application and interpretation of relentless Loper Bright, one can expect that there'll be more challenges to agency regulations. But how do you think agencies are going to react? Are we going to see less formal rulemaking, more guidance? Saw an article in Law 360 that experts are saying that they should write in more plain English and use diagrams and pictures and other things to make sort of clear, which sounds interesting to me. But how do you think the agencies are going to react, if at all, to this?
Yeah, I have to say that just called to mind the period in the 90s and early 2000s when the standard was to write regulations as like question and answer documents, which I found very unhelpful and strange. My sense is I would be surprised to see less formal rulemaking. I think, setting Chevron aside, formal rules are tough to promulgate. They take a lot of time. And, I think one way to think about what Chevron accomplished in one of its few features was that it was a stabilizing doctrine. It made it harder to effectuate really major shifts in the law. And, if you're a business trying to operate in a regulated environment, having stability and an answer that you can count on is really very important. And I think rulemakings still provide a great deal more stability and consistency from administration to administration, simply because they're so much harder to accomplish. Having said that, I think it was probably one of the reasons that the court moved the way that it did towards overturning Chevron when it did, that we've seen in recent times these wild pendulum swings in rulemakings. I'm reminded of the Waters of the United States rulemakings, NEPA rulemakings in the environmental space, but in other areas as well. And so it'll be interesting to see now in future review whether courts attempt to provide the sort of consistency and stability, and really it's got to be the Supreme Court that does it, that prevents these sorts of swings back and forth, where laws of tremendous practical importance take on 180-degree different meanings depending on who's got the presidency.
How do you think corner post is going to have an impact on the aftermath of the overturning of Chevron and sort of more broadly in the area of challenges to federal rules?
Yeah, that's a great question. The corner post, for those who aren't familiar with it, held that the 6-year statute of limitations for bringing an APA suit begins to run when a regulated entity suffers an injury. It's at that point that the cause of action accrues, and it's therefore at that point, because the APA is not subject to a statute of repose, but rather a statute of limitations, that is the trigger point for bringing suit. I think in a lot of ways, corner post makes sense, and it does represent a change, maybe not as big a change as some folks have suggested. The sort of unfair scenario that I think drove the outcome in corner post is, you can imagine, a company that didn't even exist when a regulation was promulgated, and it starts doing business 7 years after it's promulgated, and it's effectively told by dint of the rule that the government would have had the court adopt that you just can't challenge this regulation, you just have to accept it. That's a pretty tough pill to swallow. Before corner post, though, the DC Circuit had adopted a rule called the functional music test, which had said you can challenge a regulation anytime it is applied to you in a standalone final agency action, because any final agency action is challengeable under the APA. The one thing that you couldn't do, so if an agency promulgated a regulation, say in 1990, and in 2015 it applied that regulation in a final agency action to a regulated entity, even though it's many years after the passage of the initial opportunity for a facial challenge to the regulation, the substance of that regulation is baked into this new challengeable agency action. The one thing that you couldn't do under functional music, however, was challenge the procedures by which that original regulation was promulgated, but you could raise any substantive challenges. Now under corner post, if you've got a new entity that only suffers an injury later on, it seems it can also bring these sorts of procedural challenges, which is an interesting additional twist, I think, and an enlargement of the general functional music concept. But it's certainly an invitation to, creative challengers of regulations to look for ways to stand up entities that suffer injuries closer in time than 6 years to reopen the statute of limitations. I think you'll see a lot of new litigation on that basis.
Thank you. Elizabeth, you had talked a little bit about how this court is sort of prone to rule on more limited grounds where limited grounds are available, and that certainly was the case in the Jarkissi case, where they had 3 very substantial issues coming up from the Fifth Circuit: non-delegation doctrine, the Appointments Clause issue, and then the Seventh Amendment issue. Why do you think they chose to focus on the Seventh Amendment and not speak on either of the other 2 issues?
So in some ways, I think the Seventh Amendment issue was the easiest for them. So just to kind of lay out what the 3 are, one involved statutory tenure protection for the SEC's administrative law judges, whether that violates Article 2 of the Constitution. And then the second is whether Congress had unconstitutionally delegated legislative authority to the SEC when it empowered it to choose its venue for securities fraud claims. It could choose to go into federal district court or to go through an in-house adjudication. And then the third was whether a securities fraud adjudication violates the Seventh Amendment right to a jury trial. So I think in some ways, at the oral argument, the Seventh Amendment dominated. I think there were maybe 2 questions from Justice Kavanaugh about the removal issue. There were 0 questions about non-delegation. And, maybe that's because the justices just didn't want to go there in this particular case. It maybe didn't present the most, we know, I think 6 of the current members of the court have written that they're interested in exploring whether the intelligible principle test for non-delegation cases should be revisited. But this just wasn't the right, I think it was too hard of a case. The dissenting judge at the Fifth Circuit made the case that this was just an exercise of prosecutorial discretion, getting to pick which venue. And the government, echoed that in, I think, pretty effectively in its briefing to the Supreme Court. So I think that may be the reason that they didn't address the non-delegation issue. On the tenure protection, I think that was maybe a can of worms they didn't want to open, because there are other ALJs within the government that have tenure protections like this. And so I think maybe they didn't want to have to deal with, well, what about the Social Security Administration and all the other ALJs in government? And frankly, I'm glad that they went for the Seventh Amendment issue, because there have been several of these cases involving appointments clause or tenure protection issues. And what ends up happening is that the court basically takes its red pencil to the statute, strikes out the offending language, then the agency gets to reappoint the same person as the ALJ, or gets to ratify the decisions of the improperly appointed person. And so it doesn't end up making a difference for the individuals who have been hauled into this process. And so the Seventh Amendment issue is actually it's a bigger change. It's a more important, and I don't like this word, but it's a more impactful change. And so I appreciate that that's where they went with it. And, I think we'll see what happens in terms of how broad it will apply to other agencies. I think the SEC's securities fraud, its ability to choose the venue, and it was not that long-standing of an ability. I think, it goes back to the 90s. So not a super long-standing arrangement that Congress had set up for the SEC. So I think there will certainly be a lot of litigants who are trying to benefit from JARCISI and extend it to other agencies. But I think, it'll take time for us to kind of figure out which agencies actually do have this sort of coercive kinds of private rights cases that really do belong in federal court rather than in in-house adjudication.
Michael, did you want to comment at all about how broadly you think JARCISI is going to sweep? You had noted at the outset in your opening comments that there may be a pretty broad application to any kind of administrative agency fines involving fraud.
Yeah, I don't even think it's limited to cases involving fraud. I think the court's opinion is extremely broad. I think this is probably the most impactful, to use Elizabeth's word, opinion of the term. A number of agencies use the threat of administrative penalties and fines to, sort of browbeat regulated entities into compliance. And JARCISI doesn't say they can't do that at all, but it does say if they want to do it, they've got to go to a court and present their case to a jury. That's a huge difference. These agencies don't have the staff to take everything to court. And so their ability to use the threat of sometimes really debilitating, tens of thousands of dollars a day per violation kinds of fines for violations that, Elizabeth, for a lot of the folks whose interests you represent, I think, would be bankruptcy inducing. We're not talking about fines against multi-billion-dollar companies. We're talking about fines under, the Clean Water Act for, wanting to build a home on a parcel of land. It is, I think, a major shift in the way that agencies are going to be able to enforce their laws.
So let's talk a little bit about civil litigation, which is an area that has a great impact on free enterprise. Danny, this court appears to have a really strong interest in private securities fraud litigation, which is interesting in its own right. Can you talk a little bit more about the McQuarrie decision and what lies ahead in this area in the 2024 term?
Yeah, this is, kind of a new development. I think it's been fairly quiet in terms of major securities decisions in recent terms. So between the McQuarrie case this past term and two that are on deck for next term, the court, I think, has an opportunity to really clarify some rules of the road for securities class actions and to clamp down on tactics that the plaintiff's bar has been using kind of in case after case just to get past the motion to dismiss and then be able to get the settlement. So I think there are some common threads across these. Starting with the McQuarrie decision, The issue there is whether pure omissions are actionable under Rule 10b-5b, which is for misstatements or omissions in public companies. And specifically what that rule prohibits is making an untrue statement of a material fact or omitting to state a material fact necessary in order to make the statements made not misleading. So that formulation kind of makes clear that when you're talking about an omission, it has to be framed around a statement that was actually made. And that was kind of the argument here, was whether just saying in general, well, you should have disclosed something that you were required to disclose under a securities regulation is enough to bring an omissions claim. And the court unanimously said, no, that's not what this rule says. You have to be able to point to some statement that the omission renders misleading. And I'd mentioned earlier that this was a case where the difference between the parties really narrowed a lot by the time it was briefed. The main point that the plaintiffs made on the merits was that it wasn't actually a pure omissions case. They tried to say, well, this is really about statements that McQuarrie made about some risk that were half-truths because the statements were not disclosing something. The court didn't really have any patience for that reframing. This was a very short 8-page decision by Justice Sotomayor unanimously resolving the pure omissions question, and kind of just faulted in a footnote the respondents for fighting the question presented. They just wanted to resolve that, what they viewed as a question they granted cert on. So the decision does leave some questions open, like when you can reframe an omissions cases involving a half-truth, and also whether pure omissions would be actionable under other provisions of Rule 10b-5 that are about scheme liability. So there are 2 grants, as I mentioned, for next term, both out of the Ninth Circuit, both where WLF submitted amicus briefs in support of cert. So it's kind of exciting that the first one of these involves Facebook, and it's in the standard for bringing claims based on risk disclosures and public company SEC filings. And the SEC rules require companies to discuss material factors that make an investment risky. So the facts of this case are an outgrowth of the Cambridge Analytica scandal at Facebook, where a company had improperly accessed Facebook users' data and then used it for political purposes. And the specific issue is whether a company has to disclose a risk that already materialized when that risk materializing didn't actually affect the company's share price at the time. And the idea is that risk disclosures are really supposed to be about future risks and telling investors about things that might happen in the future, rather than sort of everything that happened in the past, even if it didn't really have any impact on anything. So in this case, Facebook disclosed that there was a risk that third parties could improperly access user data or disclose user data. And then the facts about the Cambridge Analytica scandal were reported and didn't really have a price impact. And the plaintiffs went ahead and tried to construct a claim anyway that they should have disclosed this earlier. And this is a technique that really allows plaintiffs to make a case out of any data breach or other type of incident where you say, well, in hindsight, the company misled investors about this event and should have disclosed something earlier. So the court is poised to kind of take that up and talk about whether whether the relationship between that risk and the future event and future business harm. The second case involves NVIDIA, and it's a different tactic that plaintiffs have been using to get past the motion to dismiss and the heightened pleading standard under the Private Securities Litigation Reform Act. In this case, it involves the cryptocurrency world, and the plaintiffs claim that NVIDIA and its CEO and some other corporate officers misrepresented the extent to which NVIDIA's revenues from sales of a graphics processing unit were attributable to the crypto miners as opposed to video gamers. The idea being that there was kind of misleading investors about exposure to the crypto space. And the plaintiffs just didn't really have anything direct to support this theory that NVIDIA misled about its kind of proportion of revenues. So they kind of tried to bank shot their way into it by claiming that there must have been internal documents that NVIDIA's CEO saw, but they couldn't actually say what those documents were, just kind of saying, well, there probably were based on what confidential witnesses said they thought there were. And then to show that the challenge statements were false, the plaintiffs hired a third-party litigation expert who sort of used some public outside information to reverse engineer conclusions about what they thought NVIDIA's actual revenues were. So these were this kind of backward, hindsight-driven way of pleading the elements of falsity and scienter, which are really important elements of a securities fraud claim. And now the court has granted cert out of the Ninth Circuit, and it's been, I think, decade plus since the court really meaningfully weighed in on those elements, which really come up in securities fraud cases. So it should be very important and interesting to see whether the court kind of understands just the ease with which the plaintiffs are bringing these cases based on any type of event or disclosure, and the need to really make sure that this pleading standard has some bite to achieve Congress's objectives and restricting some of this hindsight-driven litigation.
Another area that mass litigation targets were watching this term was bankruptcy. Danny, did the outcome in Herrington versus Purdue Pharma surprise you? And will it complicate efforts to resolve mass litigation through the bankruptcy process going forward?
Yeah, so I don't know if the outcome itself was a huge surprise. The issue, just so everyone's on the same page, is whether the bankruptcy code permits non-consensual releases of claims against third parties as part of a bankruptcy plan. And this has sort of been a hot issue in the bankruptcy community where the courts of appeals were divided. So the fact that the court, granted cert, and then I think based on the way the argument went, people realized that the days of these non-consensual third-party releases may have been numbered. And this is a very significant case in the context of the Purdue Pharma opioid bankruptcy, where the Sacklers, who owned and controlled Purdue but weren't parties to the bankruptcy, agreed to contribute billions of dollars to a settlement in exchange for a release of opioid claims. And this settlement was supported by all 50 state AGs and the vast majority of creditors and victims. But there were some objections from just a few creditors and victims, as well as the U.S. trustee, which has a watchdog role in bankruptcies. And, there isn't express permission for this type of release in the code. So there's a pretty straightforward textual argument that this isn't okay, although there are textual arguments on the other side. So I think, everyone was kind of watching and suspecting there might be this outcome. It's a very interesting lineup. I think it's maybe the exception to the rule that this is the Roberts-Kavanaugh court, because they were both in dissent. And the 5-justice majority, but with Justice Gorsuch just kind of held as a matter of the text, that these releases aren't authorized, and the structure of the code reinforces this. There's nothing in the practice that the code worked prior to the code that supports this. And then Justice Kavanaugh has a pretty remarkable 54-page dissent, joined by 3 other justices, kind of taking a more economically, practically inflected view, kind of talking about how bankruptcy is a solution to a collective action problem fundamentally, and highlighting that really the stakeholders here overwhelmingly supported the resolution in the settlement, and you needed these releases to get that resolution. And in the dissent, he said, to answer your question, he thinks that this is very likely to make it not viable to resolve mass tort through bankruptcy, because you kind of need these releases to deal with the holdout problems and with incentives that individual people have to kind of try and get to the front of the line. I think it's probably a little too soon to tell how that prediction is going to bear out. It does look like there's another attempt to kind of mediate in the Purdue case and see if they can reach some kind of resolution even without this technique of third-party non-consensual releases. But it's certainly going to put a cloud over the ability to use bankruptcy to solve the holdout problems that would get in the way of a resolution of a mass tort. And the case also leaves a lot of open questions about, short of these non-consensual third-party releases, whether other types of provisions that some courts have been allowing that kind of exculpate various parties are permissible. And I think it's a very illuminating case in terms of some cleavages in the court that aren't ideological. You have Justice Thomas, Alito, Barrett, and Jackson joining Justice Gorsuch's majority opinion, the Chief Justice, Justice Sotomayor, and Justice Kagan joining Justice Kavanaugh's dissent. And I think this is a real kind of formalist versus pragmatist divide that you kind of see other manifestations of in certain issues.
Another area that definitely has occupied a bit of the court's so-called business docket in the recent years is arbitration and federal preemption sometimes, which interact together. Business interests didn't fare so well this term in those areas, did they? Please talk a bit about the Bissonnette case and the Cantero case.
I'll try and be brief because these are fairly confined, but yeah, interesting dynamics, because I think the headline in arbitration with this court is that it's so pro-arbitration, and there's actually been a series of cases about the exemption under Section 1 of the Federal Arbitration Act for transportation workers, where the court has construed that exemption pretty broadly, like, so basically allowing a larger class of workers to opt out of or to be outside the scope of the FAA and not have to arbitrate their claims. The exemption talks about contracts of employment for seamen, railroad employees, or other classes of workers who are engaged in foreign or interstate commerce, which has been understood to kind of refer to a category of transportation workers. And the issue in the Bissonnette case is whether there's a requirement that the workers have to be in the transportation industry to qualify for that exemption. This case involved franchisees who distributed baked goods. They did other stuff too, but a part of their job was just delivering these baked goods. And the Second Circuit took the view that they were in the bakery industry and not the transportation industry, so they didn't follow under the exemption. Judge Pooler wrote a dissent. She actually passed away, sadly, while the Supreme Court case was pending, but the court vindicated her unanimously by holding that there's just no transportation industry requirement. I think, how do you explain this, given the broader pro-arbitration trend? I mean, it was a very straightforward textual decision where they just kind of looked at the text of the exemption, said, I don't see transportation industry in it, kind of looked at the precedent and said it's really just kind of focused on the responsibilities of the worker to the employer. There's not an industry requirement. So I think, I guess the court gets a lot of criticism, and a case like this shows that I think sometimes applying the standard methods leads it to outcomes that you can't kind of explain in a outcome-oriented way. And on preemption, we mentioned the Cantero case, and this is a case under the National Bank Act's preemption, and the question of whether that preempts state laws that require escrow accounts to pay interest to mortgage borrowers. So New York has this, and the question is whether for national banks that state law can be applied to them, which adds to the cost of maintaining a mortgage. So this, I alluded to this in my opening remarks. This was a case, I think, where the court just thought it was important. There was a split, and then they just kind of punted a little. The Second Circuit held that it wasn't preempted, and the Supreme Court sort of vacated and remanded. There's a Dodd-Frank sets forth the preemption standard, which looks to a prior Supreme Court case, and that sets the preemption test as whether the state law prevents or significantly interferes with exercise by the national bank of its powers. So that's not really a self-defining test. The question is, well, what does it mean to significantly interfere? How much? And the Supreme Court, in a unanimous decision by Justice Kavanaugh, kind of said, well, you just look at our precedent, look at the text and structure of the laws, compare it to the precedent, use common sense, and then just kind of sent it back. So I think there's a little bit of frustration because I think people were hoping to actually give the industry a little guidance on how this preemption works and maybe apply it broadly so that they didn't have to deal with this patchwork of state laws. And I think there's going to be more to come to really clarify how National Bank Act preemption works.
Thank you, Danny. Elizabeth, which of the two decisions that you were mentioning in the takings area do you think are going to have more of an impact for litigants that are on the pro taking side of the V, like PLF or IJ or other organizations or private landowners?
So they, obviously they were both narrow decisions. Sheets will have an impact in that there was a circuit split, and now it's clear that just because it comes from a legislature, exactions are still subject to the Nolan-Dolan nexus and proportionality analysis. So that's, that'll have an impact for litigants in a number of circuits and a number of states that had ruled otherwise. For de Villiers, the court leaves for another day whether it will look at whether the takings clause is self-executing. I thought it was interesting that Justice Thomas went on to talk about the merits a little bit. Considering some other separate writings of his this term, he criticized the majority for engaging in a little bit of dicta when it wasn't necessary, and he had a bit of that in this case. But I have to say, it's been 4 years since the first complaint was filed in that case, and now they get to basically start all over again in state court. And that, it's like when you're drawn into an agency adjudication, it's the process is the punishment, and that seems to be what's going on in Texas. And I just have to say, there was this one passage, not to bag on Justice Thomas because he is one of my favorites, but there was this one passage that just wounded me when I read it. And he talked about how our constitutional system looks to the good faith of the states to provide an important assurance that this Constitution and the laws of the Constitution shall be the supreme law of the land. And, we shouldn't assume the states will refuse to honor that. And the court was assuming a level of good faith that was not on display in this case. And this was fully aired during the oral argument, with multiple justices needling the Texas Solicitor General for having played these procedural games. I mean, Chief Justice Roberts even said at one point to the Solicitor General, isn't this a catch-22? You said they have to proceed in state court. They can't go to federal court. And as soon as they do, you remove to federal court. And then you're in federal court and you say, oh, 1983 doesn't work. So what were they supposed to do? And so I thought that was, reading that passage, I thought, really, Justice Thomas? There is a lack of good faith with what happened here, so I'm hopeful that there will be a future case that the court takes up on the big question that they ducked in de Villiers, but we'll see if they have the appetite for it in the future.
Well, thank you for giving me a segue into the net choice cases of sorts, Elizabeth. That was a really interesting outcome where you had a whole lot of opinions. The case ultimately is being sent back down to the 5th and the 11th circuits respectively because of the fact that they were facial challenges and then the record wasn't developed enough. You had Justice Thomas saying that everything that Justice Kagan said about how the 5th Circuit was wrong was dicta. He was also saying that courts don't have the authority to resolve cases on a facial challenge basis, which was an interesting point. But Michael, how do you see these two cases playing out on remand before the 5th and the 11th Circuit specifically? Do you think that the circuit will take Justice Kagan's guidance to heart?
Yeah, it'll be interesting to see. And I know we'll be talking about the relative performance of the circuits a little later. I will say, I think this case is maybe the most, to my mind, the starkest example of how the 5th Circuit, one, I think is much further to the right than the majority of the Supreme Court, but I think, I mean, it makes sense to think of it almost as politically conservative rather than ideologically conservative. It's more concerned about sort of how this plays among the political parties than anything else. In some ways, I find the net choice decision confusing. On the one hand, I actually have a different view from a lot of other folks that I work with. I don't think courts decide enough. The tendency towards minimalist decision making on the whole may have been a good one in response to the excesses of the 1960s and 70s, but at times it can feel like judges and justices sort of patting themselves on the back to see how little they can do. And, for somebody who represents litigants who really need answers to these questions, and especially questions that find their way to the Supreme Court, which means they've divided the circuits and they're debatable questions and there is uncertainty around them, it can be exasperating, candidly, not to get final answers on the issues that are fully briefed and properly presented. So in some ways, I think what Justice Kagan did here is a strange turn. But on the whole, I think it's a good thing, because if she hadn't done it, and my guess is she knew this, she and her colleagues knew this when they took this approach, I think they had a good deal of confidence that otherwise the Fifth Circuit would have just found another way to reach the same result. I think that's going to be a lot harder now. This is dicta or not, it is signed on to by a majority of the court. It is the opinion of the court. It would be surprising to see the Fifth Circuit not fall in line after this.
So one of the perennial questions that in WLF Roundup, as you sort of alluded to, is how the various circuits fared before the justices. Surprisingly, the Fifth Circuit was far more the whipping boy this term than the Ninth Circuit was. 66% of its cases reversed. Elizabeth, does this mean that litigants that are looking to the Fifth Circuit to challenge regulations or advance a so-called conservative agenda should now think twice?
So, I think the Fifth Circuit did have a higher percentage of cases at the court this term than the Ninth Circuit, but the Ninth Circuit has had a long run as having the worst, the highest reversal rate at the Supreme Court. So maybe it'll reclaim that mantle in the future. In terms of the Fifth Circuit, the judges are taking big swings. There were some important wins that came out of the Fifth Circuit as well. I mean, wins from my perspective. Jarkissi came from the Fifth Circuit. The Cargill, the case involving ATF classifying bump stocks as machine guns, and the court said that this exceeded the agency's statutory authority. That came out of the Fifth Circuit. So they weren't all losses. There were some important wins as well. But in terms of should litigators think about that when they're looking for clients, when they're deciding where to file, I think one positive thing about the Fifth Circuit is that the cases seem to move pretty fast in that circuit. You get out of the district court up to appeal en banc if necessary, and then you're at the Supreme Court in just a couple of years. So I think, for people who are trying to move the law in big ways, you getting to the Supreme Court as quickly as you can. If there's percolation on a particular issue, there is some value to that.
Yeah, I will say that one of the biggest cases that the court's taken so far for next term, at least in our world at WLF, is from the Fifth Circuit, the Wages and White Lion case, which involves FDA's review of so-called e-cigarette applications, and that came from an en banc panel, so that's definitely going to be an important one to watch. So, Michael, in the last day, the final order, Justice Thomas wrote a dissent from denial of cert joined by Justice Gorsuch in a case involving OSHA and the non-delegation doctrine. Do you think that the demise of Chevron and the rise of things like the major questions doctrine make it much harder to succeed on a non-delegation argument or get the Supreme Court to take a case that might better define what that doctrine is?
It's ultimately it's going to be counting to 4 to get a grant on a question really presenting a strong non-delegation claim. And it seems like we're just not there yet. But I will say, I think this is, it's certainly a project for Justices Thomas and Gorsuch. I think they see it as sort of the inverse issue to deference, right? Chevron deference improperly allocated judicial authority to the executive, and failure to observe delegation principles is resulting in an improper allocation of legislative authority to the executive. And I think, consistent with what I described before in this sort of huge amassment of power by the executive and the overinflated size now that we see of the Code of Federal Regulations as a result of both of those dynamics. And I think they are laser focused on fixing both. I think it's going to, it'll take another decade before we get there, but justices have been writing opinions about how terrible Chevron is for longer than a decade. And as the Chief Justice noted in his opinion in Loper Bright, it had been since 2016 that the court had even applied Chevron. So it'll take some time to get it up, but I'm confident that it's sort of the mirror image of overturning Chevron, and that we'll see it there eventually.
Before we get to questions from the audience, and I do remind you, if you'd like to ask them, please do so in the Q&A section. Are there any cert petitions that you are following or that you have brought yourselves that you wanted to mention that sort of fits into the realm of the areas that we've discussed? Michael, Danny, Elizabeth, and just whoever would like to jump in, please go ahead.
So I'll briefly mention PLF has a couple of petitions pending, but one that's going to be going to the Long Conference in September is it's a follow-on to the Students for Fair Admission case from last year, which held that race-conscious admissions at the collegiate level violate the Constitution's guarantee of equal protection under the law. And so we've had, at PLF, we've litigated a series of cases in high schools. And so we have a case involving Boston Latin School, which is a magnet school that scrapped its entrance exam in 2019 and adopted a zip code based approach to admissions. There was evidence of board members admitting that they were motivated by race, that they were trying to reduce the overrepresentation of Asian American students. And so we had a similar case out of Virginia that the court declined to take up this term, Thomas Jefferson, which is another magnet school. And so we're hopeful that they'll take the Boston Latin case next term.
Michael, Danny?
I'll add just two quick thoughts. And this is a bridge to some of the earlier comments about the Fifth Circuit and what to expect for next year. Just to add, my own view that the Ninth Circuit had such a long run of reversals was because folks who were turning to the Supreme Court to accomplish liberal policy objectives were bringing all of their claims to the Ninth Circuit. It was where you went for that sort of claim. You're not seeing those claims anymore because they just can't win at the Supreme Court. And even the Ninth Circuit now is less liberal than it once was. But I think we're seeing the inverse happening with the Fifth Circuit. And it continues to be the most favorable circuit for certainly the sorts of issues that matter to WLF and others. And, a win at the district court and a win at the Court of Appeals is still a win, even if getting it up to the Supreme Court, you may not ultimately get the decision you want. If you've got a good decision in hand for 2 years, that's a whole lot better than having no good decision in hand. And then finally, I'll briefly mention, we had 2 petitions granted just before the end of the term. These are both criminal justice cases, so a little less directly relevant to the interests of your members. But if anyone is concerned about overcriminalization and excessive incarceration, these are 2 cases that touch on those issues. One was Montague against the United States, where the Solicitor General confessed error. The court granted, vacated, and remanded to the Second Circuit. I think it's pretty likely we're going to see it come back up. The second was Hewitt against the United States, which concerns a sentencing law called the First Step Act, and that is likely to be a December argument. We'll be briefing it over the coming months.
And I've been looking at the securities cases I mentioned, and then another thing I've been watching is Lyft and Uber have some pending petitions to the Long Conference on an arbitration issue, where it's kind of in the series of things California does to get around the FAA. And I think this iteration is whether public enforcement actions that are kind of seeking compensation on behalf of rideshare drivers who are subject to arbitration clauses, whether those can get outside the FAA. So that might be more of a traditional arbitration case and outcome that we, I guess, didn't really see this past term.
Question we have from the audience, not necessarily directed at anyone, so any of you want to jump in. What can be done to educate the public on what the Supreme Court actually decided in the presidential immunity case to overcome Justice Sotomayor's false parade of horribles characterization of the actual decision? Somewhat of a loaded question.
What can be done?
Glenn can write an op-ed published in the Wall Street Journal.
There's more than enough op-eds out there on this in the blogosphere and elsewhere for people to, I think, have a good understanding of everything. Well, I want to thank everybody for joining us today. I thank our speakers for participating and taking the time to prepare, and look forward to seeing what happens over the summer and then in the Long Conference. And we'll all be back doing this once again in September. Thank you very much.